So, I'm going to try answering some questions here. So if you have questions, drop them in the chat. I'll answer those. I'm going to start answering some other questions, ones that I get quite frequently, so I can get started. So if that prompts other questions that you have, let me know. The biggest, probably the most common question I get asked, honestly, is, okay, I'm trying to settle this debt. I'm being sued or I'm being contacted by a debt collector. I want to settle it. So I've got to make an offer. What percentage do the debt collectors usually take? Like, will they usually settle for? The answer to that question really is it depends and is different, in every case. I have settled debt collection cases where they have agreed to just walk away and take nothing. I have settled cases where they will not take anything less than the full amount they want. Sometimes I'll have them even say, well, not only will we take less than we are asking for in the lawsuit, but we're demanding all of the attorney's fees as well, and they won't settle for anything different. What I usually say to people as for how to make that initial offer for a settlement is, I think the first step that you want to take is you want to make a budget for yourself. Figure out how much you can pay in a one-time lump sum, and then figure out how much you can afford in an ongoing monthly payment. And really, once you have that maximum budget set, you know that you are not going to settle for more than that maximum amount. I think the worst thing you can do is be like, I'm so afraid of what's happening, I just want to get rid of this, and you settle for an amount that you can't afford, or you get on a payment plan that you know you're not going to possibly make. So if you're being sued by a debt collector, you're going to have certain defenses. One of those biggest defenses really could be that you're going to make them prove that you owe the debt, and they're going to need to have the original contract, or they're going to need to have, if it's like a credit card, all the various statements that show all the individual purchases, and you want to keep those. You want to keep those defenses. But if you enter into a settlement agreement, then you are. You enter into a settlement agreement, then you basically are getting rid of all those defenses, and the only thing they need to prove if you don't pay your settlement is that you didn't prove the settlement. It's going to be real easy for you to do. So when you are making a settlement offer, make a budget and do not go above that budget unless you're able to change your circumstances and increase that budget. Then what you want to do is kind of evaluate your case. Like, how strong are your defenses? Do they have the documents they need to prove that you owe this debt? Really, you yourself, do you know that you owe this debt? And if you do know, then then you're going to just start with a lowball offer. You know they're not going to take your first lowball offer, but start with a lowball offer. They're going to give you a counter offer, and then you're going to negotiate in towards the middle. If you can get below your maximum amount, then that's what you want to settle for. Okay, so we're starting to get some questions here. This is from, looks like, Evolved Jazz. So the court told me to wait for them to schedule mediation. I'm not sure what to do in the meantime. So here's what often happens is you get sued and you get the summons and you get the complaint, and then the next step for you is to file the answer, and you hopefully are filing the answer and denying the allegations so that the debt collector has to prove that you owe the debt. So what you're going to do at this point is, it really is going to differ by court and differ by situation. Sometimes the court will have like an initial, what we call a pretrial conference, and a pretrial conference can be just any reason that the court wants to meet and talk about the case. And so a lot of times you'll go to this pretrial conference and the judge will order the parties to mediate. Now, mediation is basically where you're going to sit down in a conference with the other side. Sometimes you're in the same room, sometimes you're not, sometimes you're online. You may be on a Zoom call, but in like different Zoom rooms. And the mediator is just a neutral third party that's going to go back and forth between the parties and try and help them reach an agreement. A lot of times a mediator will just pass offers back and forth, or a mediator can meet with each side separately and say, look, these are where I see the strengths and weaknesses of your case. So maybe they'll go to the debt collector and say, hey, you don't really have all the documents that you need to win. So like, you really ought to consider taking a lower amount, those kind of things. So what you want to do in that case is, attend the mediation. Now, it looks like in this person's case, the court said wait for them to schedule mediation. Sometimes mediations are scheduled by the court. And so in that case, if the court tells you to wait for them to do something, you're just going to wait for them to do something. And that may be, sometimes they have court mediators, or sometimes they'll have another judge that's not over your case act as the mediator, and the court's going to reach back out to you and schedule that mediation. So you're just waiting for them. Now, just because the court's going to schedule a mediation doesn't prevent you from trying to settle the case in the meantime. You can still make an offer before mediation and see if you can get it done without going to mediation. If you do, great, the case is over. And if you can't, really no harm done. Now you're at least heading into mediation with a better starting point, better knowledge of where the case is at. But I think the other thing too is if the court says, hey, you need to mediate and I'm going to schedule mediation, and so wait for me to do that, it doesn't prevent you from doing the other things that you need to do in the case either. So, you can start sending out your discovery requests, your requests for admission, your requests for production of documents, and keep the case moving along so that, you have that information. So you send them a request for production of documents, say, I want the original agreement, I want the statements. If it's a third-party debt collector, I want the purchase agreement between the original creditor and the debt collector. And then you have that information going into mediation. You can show it to the mediator and kind of make your arguments to the mediator. So, I guess if the court's told you to wait to schedule mediation, you're going to wait to mediate. In the meantime, you can try and settle, but you should be sending out your discovery requests in the meantime. So hopefully that answers your question on that. So again, for other people that have joined, if you've got questions, drop those questions in the chat. I'm happy to answer whatever debt collection questions you have. So I've got another question here from Kristen. What about discovery in aid of judgment? Do they have to respond to your requests? So typically the way this happens is once a debt collector gets a judgment against you, they still have to get the money out of you, right? So in order to get the money out of you, there's some common ways that they get money from you when they have a judgment against you. The most common being wage garnishment. That is, not every state allows wage garnishments, but a lot do. And so in order for them to garnish your wages, though, they've got to know where you're employed, where you're working, if you have a W-2 income. The other thing, one of the other common ways is they'll go to a bank and, levy your bank account, take the money out of there. And different states have different laws on what's allowed and how much money they can take. Sometimes they need to leave a certain amount in there, things like that. But again, they've got to figure out where you bank. So a lot of states will have procedures for what happens after a judgment for the debt collector to find out that information. And so a lot of times they'll allow things like discovery in aid of judgment. It's called different things in different states. But basically they will send you like written questions that you are required to answer. Or some states will have a process where they will set a court hearing and you are required to go to the court, be placed under oath, and answer questions about your assets. And then a lot of times there'll be questions like, where do you work? Where do you have bank accounts? What kind of assets do you have? And then the creditor will use that information to take your money. So typically, if you're at this point where you've got a judgment against you, the time for you to ask them questions is really past. So this question is, what about discovery in aid of judgment? Do they have to respond to your requests? So, you can check your state's court's rules and see if there's a process for you to ask questions at this point, but probably not. At this point, once there's a judgment against you, your chance to fight the debt is really over, except under some certain limited circumstances. So your chance to question this debt or ask them for information to prove that you don't owe it, that's already passed. You were supposed to do that before they got the judgment against you. So typically what I say when people are getting these requests in aid of judgment, that's the point where you really need to think long and hard about trying to settle this case and give them an incentive to take the money that you're offering rather than, have them come after all of your assets. Of course, it's assuming you have assets. If you don't have a W-2 income, if you don't have money in a bank account that's sitting there, in some ways you're judgment proof and you can kind of say, good luck getting the money out of me. So yeah, hopefully that answers the question, but your chance to ask them questions once you are getting discovery and native judgment, that's really over at that point. Okay, got another question here from Evolved Jazz. Thank you for the discovery request. How does one request the original agreement from them? Okay, so let's assume, I don't know what kind of debt you're talking about here. I'm going to make an assumption that we're talking here about let's just say a credit card debt, but it's going to work the same if it's a medical debt or if it's a payday loan. There's got to be some kind of contract between you and the original creditor, right? So most states have this process in their lawsuit. It's called requests for production of documents. And basically you can send a request to the other side, and they can do it to you too, but you can do it to them, and you're going to ask them for any documents they have. And one of the things that they're going to need to prove is that there was a contract between you and them, right? So you want to find out, what contract do they have? Do they have a contract? So you're going to just fill out a request for production of documents form, and you're going to say, please provide me with a copy of the original agreement between the plaintiff and the defendant. I mean, you can word it a little differently or whatever. And then they've got to, within 28 or 30 days, depending on how many days are allowed by your state, they've got to respond to that and produce a copy of that original agreement. Now, if they produce it to you, okay, now you've got that information and say, okay, they've got this agreement between me and them that's signed, and that's going to be pretty good evidence for them. But a lot of times, maybe they won't have that original agreement. And then you can, go to court, go to your trial and say, they don't have an original agreement. They don't have a credit card agreement between me and them. Now, I think where a lot of people get caught is you'll send that discovery request asking for the original agreement. And especially on credit cards, you've got to remember that a lot of people these days on credit cards, they're just going to apply online, right? So there's not going to be something with like a wet signature on it. And frankly, they don't need to have a wet signature contract. They just need to have some evidence that there was a contract. So, sometimes they'll send an agreement, it's not signed by you. You can ask for the original form that you filled out or the data that they have from the form you filled out online, and you can see if they have that. If they don't have it, your case got a little better. You've got a few more defenses in that regard. But you can ask them for any document. So let's assume that there's a junk debt buyer that is suing you. So you had a credit card, you didn't pay it. The credit card company wrote it off and sold your debt to Midland Funding, let's say, which is a really common junk debt buyer. Midland Funding sues you. You send a discovery request. Say, I want to see the original credit card agreement. You ask a request for, I want to see the information from the form that I filled out online for the credit card. And I want to see the purchase agreement between the original creditor, let's say it's American Express, and Midland Funding. So if American Express sells your debt to Midland Funding, they have to have a contract there buying that debt. So you send that discovery request, and they have to produce to you the original credit card agreement, the form that you filled out online, and the contract between American Express and Midland Funding. So if they send it back to you, you can look at it and say, okay, they've got what they need. I'm going to have a hard time winning this case because they have these documents, so I need to try and settle it. Or if they don't send it back, now that's going to be your argument. You go to court with your request and say, I asked for this information. They couldn't produce it, so they haven't met their burden of proof to prove that I owe this debt. So that's kind of how that process is going to work. Now, if you need more help, I do have some of these resources up on my website at debtbrief.com. You can find 107 sample questions that you can ask in discovery requests to debt collectors. And I've just gone through and thought of as many as I could of questions that you can ask them for documents or information that is going to help prove that they don't have the information they need in order to prove that you owe the debt. So, Okay, there's a few more questions here. I've got a question from Randy. I got a judgment in Missouri. How does it work? Can I still do a payment plan? Yes. So the thing about settlements is they can be done at any time. So you can settle your debt before a lawsuit is filed. You can settle a debt while you are in the lawsuit. And actually, let's assume you go to trial and lose, or maybe you didn't respond to the lawsuit and they got a default judgment against you, and you're thinking, well, now what do I do? Yes, you can still settle the debt at that point. The only rule really about settlements is that both sides have to agree to the terms of the settlement. So if you've got a judgment against you for the amount of, let's say, $5,000, again, they've got to collect it from you. So they've got to find maybe where you're employed and garnish your wages. And there's going to be limits. Usually it's like 25% is the limit of your take-home pay that they can garnish, and they want that money faster. You know, it can be harder to settle a case after a judgment, of course, right? Because they've already got the order saying they can take your money, but they've still got to get the money, and they're limited on how much they can take and those kind of things. So, yes, you can still settle. It can be harder, but you want to give them some incentive. Maybe they're only able to take $100 out of your paycheck. It's going to take them a long time to reach that $5,000 threshold. Maybe if you can get access to a little bit of money, get a loan, or get some money from a family member or something where you can sort of sweeten the pot for them and say, look, I know you're going to take $100 from me for the next, 5 years, but if I could come up with $2,000 right now and pay you $2,000 right now, would you take that? And frankly, some of them are going to do it. It's going to be different in every case, but I guess my answer to that question is yes. Even if you have a judgment against you, you can still settle that debt. And, I think you probably want to. If you got a judgment against you, you want to get rid of that as fast and efficiently and as for a low amount as you can. So the answer to that is yes. Okay, got another question from Christian. Javits Block won't answer or respond to messages. So I assume you're contacting the plaintiff or the plaintiff's firm. First of all, once you get sued, the person you always want to talk to is the lawyer that filed the lawsuit. You don't want to contact the debt collection agency or the debt collector at that point. You want to talk to the lawyer. If they won't respond to you, then you should just continue to go through the court process. And I'll tell you, this is common, frankly, because these debt collectors, they have so many cases, and the law firms that help them have so many cases, they don't care or frankly know about your case. And so they often won't respond to you. However, one time when you are going to be able to talk to a lawyer is when there is a court hearing. So if there is a pretrial hearing or the court sets a hearing on a motion, there's going to be a lawyer on the other side. So you're going to show up to that court hearing. If it's in person, I think that's better. You should go because you can catch that lawyer in the hall, or maybe you can do the hearing, and then on your way out of the hearing, you can talk to the lawyer and say, hey, I've got a settlement offer I want to make you, or whatever it is you want to talk to them about. But yeah, don't get discouraged if they don't talk to you. You can always try and send them messages, send them emails, but that if you can get a court date, and you can just always ask the court for a pretrial hearing, then you're going to be able to talk to the lawyer about your case at the hearing. And they're going to be a little more prepared to talk about your case at the hearing too, because they've got to prepare and look at your file before they go into the hearing, so they're prepared to talk about it with the judge. So that's always a good time to talk if they will not talk to you. Okay, so I got a question here from Memphis Parsley. Hello, how many days do creditors have for informing me about the filed lawsuits against me? So this is going to differ a little bit depending on your state and what their process is. So you can start a lawsuit usually, and again, if your state's a little bit different, I understand, but this is how it is in most cases. You can start a lawsuit in two different ways. First, you can file the complaint with the court and then take that complaint with a summons and serve the other side and notify them that a lawsuit has been filed. Now, each court is going to have a little bit different rules. Like in Utah, I think once you file that lawsuit, you've got 120 days to serve the summons, or the court will dismiss the case. Different states might have different deadlines on those. And so if you haven't notified them by then the court's going to dismiss the case. The other way you can start a lawsuit is actually in the reverse. So you can serve them with the summons and the complaint. And then, like, for example, where I work in Utah, If you serve them, you've then got 10 days to file the lawsuit after you've served them. And if you don't do that, then the case can be dismissed. They don't always do this though, right? Because they're trying to find you and serve you, and frankly, some of these creditors are a little bit shady in their business practices. So let me give you a scenario. They file a complaint against you, right? They don't notify you. They're supposed to serve you with a summons and complaint. Maybe they try and serve you, but they've got an old address, or maybe they just don't, right? Because they're not really following the law. And then they're going to go to the court and say, hey, we tried serving this person with the summons and we can't find them. Or we think they're home and they just refuse to answer the door, so they won't accept the summons. Sometimes that may be true, sometimes it's not. And then the court's going to say, well, you tried, so I'm going to give you an alternative way of service, and I'll say if you just leave it on their doorstep, I'm going to count that as service. They do that. Maybe they don't do it, but they tell the court they do. And then when you haven't responded because you never got notice, they get a default judgment. So I guess to answer your question, how many days? It's going to differ depending on the rules of your state. But, they can have up to, 4 months to notify you after they've filed a lawsuit. If you find out you have been sued and you have not been served with a summons, it is usually in your best interest to show up to court and file an answer and appear and fight it. Otherwise, you're going to get that default judgment. Now, if you haven't been served, you can file a motion to set aside the judgment to sort of wind that clock back and undo it and tell the court, hey, I was never served. They never did do these things that they told you they did to try and find me. But that's going to create a lot more work for you. And it doesn't always work, right? The court doesn't always believe you. So if you find out about a lawsuit against you, even if you haven't been served, you're usually better off just answering. Okay. Getting a lot of thanks for these questions. Of course, I'm happy to help. That's why I'm here. I don't like these creditors taking advantage of people just because they don't know the rules. I mean, I'm always one that's going to say, if you've got a debt and you know it's yours and you know they can prove it, you're going to try and settle that and get a fair result. But what I don't like is people taking advantage of people like you by using the court rules against them just because they don't know the court rules. So that's really why I'm here, is to educate as much as I can about the court process. There's no guarantees that if you follow what I am teaching that you're going to win your case, right? I want to be very clear on that if they can prove that you owe this debt in court, you are going to lose. But what I really don't want you to do is lose because you didn't know the process. So let me, I got another question here. How do I stop a wage garnishment? So, let's assume you've got a judgment against you. They're garnishing your wages. And what you're going to do at that point is you're saying, okay, they know where I work. They're taking this money out of my paycheck because they've got a judgment. Now, let's assume that you didn't know about this lawsuit and you found out about it because they've garnished your wages. What you're going to do at that point is you are going to, you can file a motion to set aside the judgment. You can find that form on my website. But what you can do at this point is you're basically telling the judge, hey, I just learned about this lawsuit when they started garnishing my wages, but they did not give me any notification of the lawsuit. They didn't serve me. Because they didn't serve me and the court rules require them to do so, the judgment was improperly obtained, so I want you to set it aside. Hopefully if you do a good enough job convincing the court that it was improper service, they're going to set aside the judgment, and it's not going to get rid of your case, but it is going to start the case back from the beginning so you can defend it. So that's one way. You still got to fight the case and prove that or at least prove that they can't prove that you owe the debt. Another way to get rid of a wage garnishment is just to let them pay the full amount off, right? Just let them garnish your wages until the full judgment is paid, and then you can file a motion to declare the judgment satisfied. Another way is to settle the debt, right? So this question came up earlier. If they've got a judgment against me, can I still settle? Yeah, they're garnishing your wages. So you give them an offer to try and settle that is enticing to them. Now, if you're offering to pay them a payment plan that's less than the amount that they're garnishing, they're probably not going to take that because they know what they've got there. If you can give them an offer to pay them maybe more per month, but for a total less amount, like that's a good thing. Like, let's assume they're garnishing $100 a month from you. Maybe you can say, look, I'll pay you $250 a month, so you're going to get more, but instead of paying you this full $5,000, let's do $250 a month until I hit $2,000, or whatever those numbers are that you reach. So settling the debt is another way to get rid of a wage garnishment. I mean, another way is you can quit your job. They're not going to be able to garnish if you're not making money there. You can go find another job. Of course, they're always going to be on the prowl and looking for you to find another judgment or find another employer to garnish wages from the next employer. But they've got to do that. And if you're hopping around and moving to different employers, that's a lot of work for them, especially if they're not getting a lot of money out of you. And but that is another way to do it. Also, to garnish wages, you've got to be a W-2 employee. So if you are working in your own company and just taking like a draw out of your LLC rather than, getting wages, that's another way to not have them garnish your wages as well. So we're coming up on the half hour. Hopefully this was helpful for all of you. I want to do this again, so I'll probably send out some notifications when I'm planning to go live again. But if there are any other questions before we finish up, just drop them in the chat and I can answer those. But I just want to finish off, unless there are any other questions, and just say that, like, I know that debt collection can be like a scary thing that can happen to you, and you're going through the court process probably for the first time. You don't really know what it entails. You don't know what to do. But what I want to say is that, like, you are perfectly capable of taking this on and dealing with it. Like, this is what I do for a living, is I help people that are in this situation. And I've helped so many people that didn't think they were able to take care of this and were scared, didn't know what to do. All you need is the knowledge to take this on. And as long as you have the knowledge, you can fight it. You can deal with it. You can settle it. In a lot of cases, you can take it on and win your case. And that's hopefully the goal of what I'm trying to accomplish here today, is to give you some of that knowledge so that you can fight back against some of these unfair debt collection practices. Of course, if you need more help, I'm going to be going live here more often on TikTok. I try and post a lot of videos on my channel as well. So you can always check that out. And then I've got a lot of resources up on my website at debtbrief.com. If you need court forms, I've got them for sale there. Again, those sample discovery requests I think are really helpful. I've got those up at my website. If you want to meet with me one-on-one and answer questions, I do consultations as well. You can sign up. You can sign up for that by just sending me a DM here on TikTok, or you can go onto my website and fill out the form there. I'll contact you about scheduling a time. So if you need more help, head to debtbrief.com. Okay, I've got another question here that I'll answer before we finish from Cody. I filed my answer. I don't think I've heard anything. How many days do they have to come back? Okay, so this is a good question. So they serve you with a summons. You file your answer. What happens next? Nothing has to happen next. They don't have to send anything else to you at this point. If they think they have all the proof they need to prove that you owe the debt, they can just wait for the court to set a trial date, or they can ask the court to set a trial date. And usually cases have like a predetermined number of days that they have to just be open before they can go to trial, like 6 months or something. It depends on your state, again, and your court. But the debt collector doesn't have to do anything during that time. All they have to do is wait for that trial date, and then once that trial date comes, they show up at the trial and present their evidence that you owe the debt. So it's not uncommon for you to get nothing from them until you get a trial date. Now, so the question is, what should you be doing during this time? I think what you definitely want to do is send a set of written discovery requests. Again, we've talked about those on this live earlier. If you've joined late, you can find those forms on my website, as well as sample questions you can ask. You want to be asking them questions about what information they have about your debt. Do they have an original contract? Do they have statements? Do they have a purchase agreement if it's a third-party debt collector? do they have this information? Do they have these documents in order to prove that you owe the debt? You want this information from them because if they have it, then you know you've got a pretty good chance of losing the case and you want to, maybe think about settling. Or they're going to respond with, we don't have that information, or they don't respond at all. And then you're going to know, okay, I've got a really good chance to win this in court. And now you've got a little bit of evidence at court. So that's what you want to be doing in the meantime. So Cody's come back with a follow-up. I asked them in the answer about the purchase agreement because my name is not on there. So you can ask them in the answer. They don't have to respond to your answer. The answer is really just, I'm responding to the allegations made against me in the lawsuit. And you can put whatever you want in the answer. If I was a lawyer for a debt collector and I served a summons and a complaint, and then the defendant served an answer, and in the answer they said, hey, why doesn't the purchase agreement show my name on it? I'm going to completely ignore that, to be honest with you, because there's no obligation under the court rules for me to answer that. I'm only going to answer that question if you follow the proper court procedure by sending me the written discovery request. So you can maybe send an interrogatory, which is just a written question that says, why doesn't the purchase agreement have my name on it or something like that? Or send a request for production of documents that asks for a copy of the purchase agreement or asks for a copy of the purchase agreement with my name on it. And then me as the lawyer of the creditor is going to have to respond to that, right? Because you've now followed the formal court procedures. Now, if you've already got the purchase agreement from them because maybe they attached it to the complaint, then you know that your name isn't on there. And that's going to be your argument at trial, right? That they have a purchase agreement here that Midland Funding bought this debt from American Express. And this is really common, by the way, is it'll be a purchase agreement and they'll just be like, they're buying, 50 accounts with these account numbers and your name's not on there. And that is going to be your argument. It says, how do we know that my account is in these 50 account numbers? You don't, judge. And so they have not met their burden that my debt was actually purchased. So that's your argument, right? Now, Cody says, I need to get that form from you. You can find those forms if you go to debtbrief.com and then you head to the shop there, you can get those forms. The basic forms package has the discovery request forms in it, and then you can add on the 107 sample discovery requests. Sometimes your court will have those as well. Okay, so Cody's saying I already paid you and talked with you. Okay, send me a message, Cody, and we'll make sure that you get that information. So we'll make sure you get taken care of. But for anybody else, that's on the website there. But Cody, if you send me a message, we can talk offline, and I'll make sure you have that information. Just send me a DM, and we'll get you taken care of. Okay, so that's gonna be it for today. I had until 12:30. So hopefully this was helpful for you. Again, if you have more questions about your debt collection case, you can follow me here on TikTok, or head to debtbrief.com where you can find out more information. Okay, thanks.